This is The Briefing, a podcast presented by Mussio Goodman Law Firm.
So what happens is if you're married at the time of your passing, you have an obligation in law called a legal and moral obligation to provide for the spouse. So I can gather there's a lot of people, or some people, that would rather not provide for their spouse because they had a rocky relationship, but nonetheless, that's not allowed in our law. So you can do a wills variation claim if you are disinherited or the inheritance is not sufficient. So the way the law looks at it is they say, okay, let's assume for the moment that you divorced on the day of the death. And so if there was a family law matter proceeding, what would you get in terms of spousal support, in terms of distribution of the family assets? So that's what's called a legal obligation. So the court will vary the will to accommodate that legal obligation. And then the second thing is the moral obligation. So what the court will do is look at who else is entitled to money under the will and value under the will, such as children, such as parents, such as friends and family, and make a decision on what else is right. So it's wide open for a court to change the will. So in summary, if you're a spouse and you have been disinherited or restricted in the compensation you're receiving under the will, you definitely have an entitlement to and an opportunity to basically go to court or negotiate with the beneficiaries to change the will.